Good evening. Welcome to Town Council Work Session September 6, 2018. Roll call.
Second.
Rosen present.
Bennett present. Buffalo present.
Hallway present.
I do not know we have a forum. Order of business today is overview of the 1991 annexation agreement and overview of the eminent domain process. I'd like to ask council to have each presentation to be given, and after each presentation, ask what questions you may have at that time. Just these questions we ask from council only at our work session, so please all refrain from asking any questions. Thank you very much, Mr. Sherman.
Okay. Thank you, Mayor. I will. I'm going to start off with the annexation presentation, and some of you have lived through this, or at least parts of it. Some of it goes back to a lot of people in the town were adults, even if they lived in the town. So there's a lot of history here, and when I got called in to work on some annexation-related issues over a decade ago, we had to do a lot of historic research to find out what had happened in the days past. So I'm going to give you a little history of this, and that might help set the stage for you to make decisions as council members, for those of you who are on various committees, to think about how that might impact what you're doing, and as citizens of the town understand what's transpiring. So with that, I'm Mike Sterling, and for those of you who haven't met me, I'm with Van Eaton Black law firm, and I've done a lot of work for the town over the years. But I gave a presentation last month on procedural issues in the town, some related concepts, ethical issues. My partner, Chris Ambrosio, assisted me and traded off. He does a lot of work for the town. It's tough to listen to one person. I appreciate your patience. Chris just had a hip replacement, so he couldn't make it up here today. So with that, I'm going to go through this history just a little bit. This started back in March 1990 when the town entered into an agreement with Brown and Root to partition certain property. Brown and Root was the predecessor to Brown and Kellogg, which then sold the property down the road to Bay Creek and Baymark Development. And we'll see these names come up, but a lot of times throughout this presentation we'll talk about Brown and Root because what starts with them continues. A lot of the agreements that were made kind of roll over, and they run with the land, as we say, and they still impact the owners of property within the annexed area. So it began in 1990. The town filed a notice with the Commission on Local Government. This is the process you go through to bring more property into a jurisdiction. And the town also served notice on Northampton County, which opposed the annexation and wanted to keep the property as part of the county. The area proposed for the annexation was basically undeveloped, and it was generally from the southern boundary of the town to the old Plantation Creek. It's about 12% of it was covered with tidal water, about half was dry, industrial, and the rest was agricultural. The area contained some right-of-ways belonging to the railroad and the Port Authority, 2 water wells serving the town, and 1 small commercial office and 1 home. And over the years, because of the annexation, that has resulted in some negotiations and what have you that had to go on with the railroad, the Port Authority, and some of those prior owners. Brown and Root owned most of it. It's Brown and Root Inc., a subsidiary of a big construction firm in Texas, and they plan to develop this property as the Accomack Plantation. You'll notice that Accomack is one of the spellings of the Indian tribe, different than it's spelled for Accomack County, just north of us. But the idea was they were going to put in a big retirement resort community. That was the thought back in this period of time. One lawyer represented the town and Brown and Root in the annexation process, and that was before I was involved in this. The plantation, the plans called for the development of about 3,000 dwelling units. Just think about that for a minute. Over 20 years, together with retail businesses, a hotel, marina, 36-hole golf course, and other facilities. And Brown and Root conditioned its plans on the incorporation of the area in the town and the extension of town utility systems to serve the plantation. So Brown and Root wanted the development to be in the town and not in the county for a lot of reasons, such as the fact that the town had water facilities, sewer facilities, and things like that, and other infrastructure that would be helpful to the development that the county didn't really have. So, in 1991, the Commission on Local Government issued its report on annexation. It's a big, long report, public record. Among other things, they noted that the Crown Group entered into the agreement and committed to supporting the proposed annexation and investing its resources into expansion and enhancement of municipal facilities. Something similar, but not the same, to what goes on in big commercial developments where the developer makes certain commitments to do certain things. There's some limits in what developers can commit to do, or maybe say differently, there's some limits on what public bodies can ask developers to commit to do for building a development with respect to, utilities and things like that. But in an annexation, it's different. It's a wide open negotiation. So there's a lot of discussion up and back about what Brown Group would do in this process. And I'll go over some of the key provisions. The study is very long, the commission report is very long, the agreements are fairly complicated. Try to boil this down to some of the key provisions which, over the past decade or so have given rise to some, or affected some issues, let's put it that way, and may have some impact in the future. So one of the issues is that Brown Group was going to be responsible for the cost of planning and development of its property and studies by qualified planners, environmental engineers, golf course architects, marine consultants, and other experts to come in, and then they would use these results to present to the town. So that was helpful, so that a lot of the cost of planning this development was on Brown Group shoulders instead of the town. The town would benefit from that by reviewing it, studying it, maybe hiring some other consultants to kind of help review it for them, but it took out a lot of what I'll say the underlying expense at the time of this work. One of the key provisions for Brown Group was that the town agreed that it wouldn't discriminate against any portion of the parcel that was annexed, and it would apply its laws and its ordinances and regulations following the annexation of the property the same as it would to anybody else in any other part of the town. So it was basically an integrated process, so that everything has to be uniform. The other issue was that contingent on the available natural resources, the town agreed to extend water and treatment capabilities to Brown and Root's properties, and to reserve for Brown and Root water and sewer treatment capabilities in sufficient capacities to serve the completed development. And then the language here that I put up in red is of significance. Brown and Root agrees to pay the cost of the physical expansion of the town's sewer and water treatment systems, which are the collection, distribution, and treatment to accommodate the additional treatment demands of Brown and Root property beyond the limits of the town's current permitted capacities. That's kind of a technical term. It's permitted capacities. It's not capacities. It's not what you might, it might be a capacity from an engineering standpoint. It's a capacity from the standpoint of a permit that's issued by a state agency. So we start out with a permitted capacity, and the issue is, do they need to be expanded, or are they already enough to serve what's out in this developed area? In fact, in 1990, when they were thinking about adding 3,000 residential units, it was very likely that that was going to be required to increase the permit capacities. The next thing that happened, part of the agreement, was that that Brown and Root agreed to construct the physical improvements within its property to accommodate the sewer and water services. So they would, on their end, they would make sure they could receive the extensions that were brought up by the town. And the town agreed that its water and sewer treatment systems would be operated by qualified licensed professionals, which back in the old days wasn't done, and that the plants would be operated to a standard at least equivalent to that prescribed by state and federal regulations. Now, in theory, the town was doing that back in those days. It was added another requirement to make sure that that was being done. And then importantly, as I mentioned earlier, the provisions of the paragraph and most other provisions of this agreement run with the land, and they're binding upon the town and any entity that assumes the responsibility for sewer and water treatment services for Brown Root property. So if the town, for example, participated in creating a water and sewer authority and transferred the water plant and the sewer plant to that authority. All these requirements would then go over to that authority. They can't just go away. The red language I put up in the slide to highlight is of significance in the event the town pays or receives compensation for the water and or sewer treatment systems following improvements to either of these systems by Brown and Root. Brown and Root shall receive a share of said compensation in direct proportion to the Brown and Root share of funded flow capacity. So this is another sharing agreement whereby, you know, if the town brings in money, whether it's from grants or whether they, you know, bring it in from other sources, they have to share that with Brown and Root in various formulas that are set forth in the agreements. Next issue of significance is that Brown and Root covenants and agrees that the obligations set forth herein shall run with the land and be binding upon the owners of its property, their successors, and assigns. So, as I mentioned earlier, Brown and Root, once they sold that development, the people who bought it take on that obligation. And later, I'll get to a slide which talks about a little refinement of this, which is for the individual property owners. So although these obligations run to Bay Creek as an entity, it doesn't run to someone who buys a house there. So we'll get to that slide in just a second. The projected need of a 1.32 million gallon per day at the completion of the plantation. That was the projected need. And that would be within the existing town, 0.21 million gallons per day, and 1.11 mega gallons from the area proposed from annexation. So you can see it's like a five-fold increase over what the town is concerned. And it was anticipated that the package plant, as the water treatment plant, would need to be replaced. I'm sorry, the sewage treatment plant would need to be replaced. That old package plant, literally was packaged, we bought it in parts and kind of assembled it on site. And also, because of changes in the regulations, there'd have to be tertiary treatment, which is a much higher level of treatment of wastewater. On the water supply side, again, back in 1990, the town's water plant had the capacity to treat 0.325 megagallons per day, but the permitted pumping capacity for the town's two wells was only 0.261 megagallons per day. So the plant was greater capacity than the wells. The town's demand was reported to be 0.150, which was less than the permanent capacity, less than the well's capacity, leaving a reserve of 0.11 megagallons per day. So there could be some more draw on that without drilling new wells. But with all the anticipated added units, Brown and Root drilled 5 added wells with a permitted capacity of 1.1 million gallons per day, or they at least they obligated to do that, contingent on a study confirmed that the wells would not draw water outside the limits of the plantation and would not result in saltwater intrusion, because that's always an issue here with our water table, that if you pump too much, salt water moves in, and we've had some changes in the town over recent years to change which wells are used and the treatment of the water, because that's happened a little bit over time. Now, Brown and Root planned to retain title of the added wells but make water available to the town, planned then. And then in the submittals to the Virginia Water Control Board from Brown and Root, they projected that the plantation would require 1.1 million gallons a day of groundwater when completed, and that 2 additional wells may be needed to meet future demand. So this kind of happened over time, and these are all big plans to build a lot of water capacity and a lot of sewer capacity for a lot of people. Brown and Root also advised the Commission that it has agreed to coordinate construction of residential units on its property with the expansion of the town's water treatment plant. So you want to get out in front. You don't have a lot of residences built, a lot of people moving in and not having capacity to treat water. So there's planned coordination on those 2 ends. And then this goes on for a while. It starts in March of 1990. We finally get in about a year later, in February 1991. And the Commission issues its report. And they make a lot of recommendations regarding utilities. And I'll summarize them in a few slides, because these recommendations were adopted and they modified this agreement that had been initially entered into. So first, the Commission recommended that the proposal for wastewater plant improvements be formally adopted by the parties. It was a proposal, but they wanted this to be documented in part of the parties to agree to it separately. outside of the annexation agreement and were to be referenced in the annexation agreement. They were just trying to add some, what I'll call details to the agreement so that it's easily understood. And the proposal for water and wastewater treatment that was, on the table at the time was to make the capacity of the plant, remember I told you about capacities, permitting capacities, be based upon the State Water Control Board regulations. And that was the old name of the, now forgive me, maybe somebody can remind me what the new name of the State Water Control Board is, just this one line. But they changed their titles over the years, but it's the state agency that's regulating the water and the water wastewater. And then also provided that should the town construct additional capacity beyond that provided by Brown and Root, then such additional capacity may be used to extend the unit construction limits otherwise applicable. So here you have the town doesn't have enough. Brown and Root has to build more, have that capacity to build the residential units, but then if the town adds capacity, Brown and Root can use its share of that and add even more units. So it's kind of a leapfrog effect. And Brown and Root agreed that it would monitor the town's wastewater treatment capacity and coordinate the expansion and development of its project accordingly. And finally, Brown and Root the town authorized Brown and Root to file the necessary applications for the plant's expansion. And the town agreed to, go through that permitting effort, which is always a big deal when doing something of this nature. So the next item in the commission findings that they recommended that were adopted is that change the 1990 agreement we started out talking about from March of 1990 to provide that Brown and Root would be responsible for all costs of sewer plant improvements up to and including tertiary treatment, because it was a little murky as to whether they would have to pay for tertiary treatment, which has a lot of costs for the type of plant you have. So that was added in. And third, the commission recommended that no industrial waste be allowed without pre-treatment by the plantation or added payments for plant modification. It wasn't really anticipated that there would be industrial waste out in the plantation, but just in case that was put in there. And the final one of note is that the commission recommended that the agreement explicitly provide that any reservation capacity for the use of the plantation be derived from the capacity created by investments in the municipal system by Brown and Root. So reservation capacity. Think about that. There's a difference between what you use versus what's reserved for your use. And for the most part, the way the town works is it's first in line. You get a permit, put a house up. If it's granted, the town has already determined there's capacity to supply water and sewer to that house. Well, if you run out of capacity, you're not going to grant more building permits until at some point the plan is changed. So there's a difference here between what the plantation doing that happen is to run out of capacities. They wanted the right to invest and reserve capacity for themselves instead of having to just come on a come first served basis. Then let me see how I put this here. Okay, skip one. Also, the commission observed that there were some conflicts, and one of the interesting things is they observed that some of what's in this agreement might not have been binding on the town. They have this very complicated constitutional issue, and Dillon's rule about, what agreement one council can make that's binding on the next council and it's binding on the town for years. And they observed, not opining on whether they're right about this or not, but the commission observed that they believe that some of the provisions in this agreement might not have been binding on the town. But even after they brought that to Brown and Root's attention, they said, we still want to go through with this agreement. So later in 1991, we're in June now, a lot of planned improvements are funded by the town. This is on the town side of things, water lines, putting new water lines throughout the town. Some got carried out to the plantation. New water plant is funded. A new water storage tank is put on. And the total cost with engineering and legal is about $3.1 million. A lot of complicated trade-offs went in. I'm not going to go through all that, and it all predates my involvement anyway. But some things were done by Brown and Root, some things were funded by the town. It was all reconciled at one point. And based on the commission's findings, the parties amended their agreement, and they entered into an agreement dated November 25th, 1991, and it generally implemented the commission's findings that we just went through a minute ago. So real quickly, there's amendments that the parties would abide by the proposal for water wastewater treatment plant improvements. Brown Root agreed to pay for its share of wastewater plant expansion, including tertiary treatment, and the parties agreed that no industrial waste would be accepted without pre-treatment plant modification. And then Brown Root and the town agreed that any reservation of treatment capacity in or from the town's water or wastewater systems was provided in the prior agreement for use by the plantation should be derived from the capacity created by investments in the town's water and wastewater systems made by Brown Root. So again, that's this reservation issue I mentioned. That's important that you need to distinguish from the use issue. Now I'm going through this agreement in the order in which it's in, but I changed topics for just a minute here from water and wastewater to the roads. The amended agreement also incorporated the terms of paragraph 4, Schedule A for road improvement from a three-party agreement between the town, Northampton County, and Brown Root that was dated November 25th, 1991. Many agreements are all kind of incorporated together. And this is long, I'm not going to read the whole thing, it's got a handout, you can look at it. But basically it had to do with acquisitions of a lot of rights of way and a lot of planning, and there would be the construction of a new access corridor from Route 184 across the property that was owned by Martin at the time into the Brown Root property. And then it provided that Brown Root would commence construction after they went through all these steps to get approval by VDOT, and the agreement sets forth what has to be done. There has to be traffic studies and things like that to get to the point where this is done. And then if it wasn't approved by VDOT, there was a way to resolve this. They'd have to submit to binding arbitration. But this essentially becomes moot because they don't build as many residences. The traffic studies are never done. And ultimately, we have the 642 route approved by VDOT more recently. That's just been done out there, which as a practical matter sort of moots all these issues in the agreement related to the connector that we just talked about a second ago. A couple of things happened. One is they never built enough to get to the traffic study that would justify VDOT coming in and building what was originally planned, and then over time, the state decided to do this extension or improve 642. Now I come to both this three-party agreement, which has in it a provision which shows up some other places also that I mentioned, which is important, saying that subsequent purchasers of individual lots or other incidents of individual ownership shall not incur the obligations of Brown Root. So the idea was to separate out what I'll call the kind of commercial entities obligations were from someone who might just go in and buy a house or a townhouse or a condo or something like that. It's the intent of the parties not to impose those obligations on those purchasers. Otherwise, and again, when it was before, provided the obligations of Brown Root would run with the land, and whoever they sold to next would pick up those obligations. So, after we go through this 1990 agreement, the commission study, the amendments to the agreement, finally represented to the court, and on November 26, 1991, the court entered an annexation order that was conditional on the parties abiding by all these agreements. The November 25th agreement between the town and Northampton County, November 25th agreement between the town and Bayshore, which by then was Bayshore instead of Brown Root. The town to hire a full-time professional planner. The town had not had one up to then. Then the old March 1990 agreement would be amended to conform to the utility recommendations of the commission, which we just went through a few minutes ago. And the March 90 agreement to be amended to require Brown Root to give a preference to work by local contractors from Northampton and Accomack counties if they went forward and built all this. And then the town would extend public services to the annexed area in an orderly fashion. And actually, I think Bayshore agreement, that probably is a long name or rename that later. That probably was still the Brown Root agreement back then. Oh, I'm sorry, you're right. I've got my orientation switched. Yes, because that had to do with it. They had certain rights also in this property because they were. Yeah, exactly. So that's thanks for that correction. I appreciate that. So all those agreements are referenced in there, and then this order provided that the town will amend its agreement of March 13th to provide that Brown Route, based upon the traffic needs, would go forward and deal with Route 184. And as I mentioned, that was incorporated in there, but subsequently overtaken by fence. Then there's other agreements. And so we got these amendments to the agreement of March 1990, and then we have this three-part agreement between the town of Northampton and Brown Route, mainly dealing with Route 184, and then also required Brown Route to limit restricted covenants so that it couldn't build more than 3,000 units in the plantation. All right, so that really, that's the kind of like a lot of historic background there of how we got to where we are now. You know, back in those days, you know, there was a lot of, you know, belief that that there would be 3,000 units built out there. Now, there's another related circumstance that happened, which I just bring in here for a little bit of clarity, which is the plantation PUD. So, in February 1997, the town approved the Accomack Plantation Plan Unit Development, known as Bay Creek PUD now. And if you want to look at that, that's on the town's website. Notably, the PUD is not identical to the annexation area. You know, a lot of times there's confusion about that. Everybody thinks, oh, the Bay Creek PUD is the annexation area. No, it's only part of it. So if you look at the next slide, it's kind of side by side, makes it a little hard to see from there. There's an appendix from the commission report on the left and Exhibit A, location map for the PUD on the right. The part of the PUD north of Washington Avenue and east of Fifth Street, which was part of the north tract of the PUD, is not in the annexation area. So the PUD is more than the annexation area, or is different, I should say, than the annexation area. They're not identical. And it's important because when you're dealing with land use issues here in the town, you know, whether you are an individual landowner, or you want to get permitted, or what have you, or in the town, and you're in the planning commission, or the town's issuing a building permit, or you're in the council and you have to make a decision, you have a really complicated set of overlaying obligations for different areas of town. You know, you have the historic district, you've got the waterfront, you have agreements that were made with various developers, and that that affect what the town can do. Various projects that went forward, like Southport has certain interests that have to be recognized. So really, for a relatively small community, you have a very complicated land use plan. You always have to be aware of that, not to jump to conclusions and kind of really study it before you make a decision.
Okay, can you just repeat that? The piece on the north is not part of the annexation?
Yes, that's correct. That's correct. Yeah.
Yeah.
It was already part of the town.
Yeah, okay.
So when they planned this development, they wanted to annex a lot of property, but there was already a part of it that was in the town that they wanted to develop. All right. So then I want to talk about the STIP a little bit. So there's another overlay of this whole situation. So in 1996, Northampton County closed on the purchase of 50 acres of land from Brown Route. So now they bought land back from Brown Route, okay, for a sustainable technology industrial park. See, there's a typo for industrial, I apologize. Called STIP. On December 1997, the county transferred, this is, a year later, they transferred 160 acres, including the 50 that they bought from Brown Route, to the Industrial Development Authority, the IDA. And then subsequently, the IDA transferred the land back to the county, and at the same time, the STIP was mostly vacant. So I don't have the exact date of that, but the STIP didn't work out the way it was planned. So it went back to the county. And then in 1996, a portion of the property adjacent to and near the harbor was leased from the town to the IDA for operation of the STIP. And at that time, the parcels were vacant except for the old wastewater treatment plant on parcel 17, which is where the new one sits now. And it was a lease term of 4 years.
The new one's on parcel 14.
What's that?
The new one's on parcel 14.
Oh, you're right. I'm sorry. You're right. That was a mistake by me. In 2007, the lease of parcels 14, 17, 19, and 20 were assigned from the IDA to Southport Investors, LLC. And also in 2007, the town signed a lease with Southport for parcels 10 and 12. The ones on the east end of the harbor, closer to where the Coast Guard is. Parcel 10 was later consolidated into 12. The lease term is 40 years, commencing on Southport's acquisition of the STIP. And then there were some options to purchase. And in 2008, Southport purchased the remainder of the STIP, about 120 acres, from Northampton County. And Southport's plan is to develop a yacht repair facility-related business, which we're already well into and hopefully thriving over there. And then sort of the parallel with this, a new wastewater treatment plant was constructed on parcel 14, as was just noted, and the old wastewater treatment plant was dismantled from parcel 17. And then in 2011, the town of Southport settled a dispute regarding the wastewater treatment plant construction by reconfiguring the lease covering parcels 14 and 17. And then in May 2014, Southport began operating the Cape Charles Yacht Center on the leased parcels. In June 2016, Southport purchased parcels 19 and 20, and we anticipate that Southport will acquire parcels 12 and 17 this year. That's they're going to have options to do that. So that kind of gives you a background on all the land, and all these overlaying obligations from the annexed town, the original town, the annexed area, the PUD, the STIP, the Southport property, that all have to relate with each other and get along with each other, if you will. So, one of the issues that comes up is, well, how does this all affect utility rates? And what does this mean for utility rate purposes? So let me give you just a little background on that. So in August 1998, the Taft Group prepared a utility rate study for the town, and it had some recommendations. It said, review financial forecasts and utility rates on at least an annual basis, and then make sure the rate recommendations serve as an integral part of an overall economic plan. It gives the town the ability to acquire the necessary infrastructure on an as-needed basis and pay for them out of tap and usage fees. So you want to have a plan. You just don't want to be stagnant. Things will change, population will change, technology will change. You want to have a going forward model. And in November of '98, the council adopted the new utility rates that were recommended by Taft. There was no change in the rates for the town. Bay Creek and STIP were set at the same rates. Tap fees set the same for all users. But a later study found that the rates were probably set too low. And so that led to a lot of discussions and changes, and eventually in March 1999, Baymark entered into an agreement with the town to reconcile which party was responsible for various costs related to all of these issues, and it was agreed that the town owed Baymark $295,000 for costs advanced by Baymark for work of the Taft Group and the law firm of Mason Valentine and various other contractors. And then that led to further discussions about the rates, and the town advised Baymark that they would revise the rate study for a new rate that would not include capital improvements, which are the responsibility of the successors in interest of Brown & Root, in other words, Baymark, under the terms of the annexation agreement, and the town then obtained a new rate study. So the whole idea was, the first rate study got the numbers wrong for a lot of reasons, but they also didn't contemplate that Brown & Root, that Baymark would have to pay for improvements to the water and wastewater side. So it all had to be done from scratch, and that's what was done in 2000. In 2001, the town wrote Baymark and said they'd done an analysis and a presentation to compare and contrast the capital and operating costs. And the analysis eliminated capital costs for which Baymark is responsible and basically revealed a snapshot of the utility system showing that they are not even covering their operating costs. There was a real problem with what was going on in the town at the time. And then there was an attached statement showing certain tap fees used as credits against the $295,000 owed by the town to Baymark. So basically, the town didn't write a check back to Baymark. There was, credits and debits offset the debt. Then we kind of jump ahead to 2004. There's an ordinance amended. Ordinance was passed to amend and increase the water and sewer fees per rate study. So in addition to the $875 sewer connection fee, a facility fee of $1,375 added for a total of $2,250. And then in addition to the $875 water connection fee, a facility fee of $875 is added for a total of $1,750, basically for a total of $4,000. And then in 2005, the town adopted water and sewer fee formula for commercial and industrial use to conform to equivalent residential unit of 125 gallons per day, which is really what was looked at for these rate studies. And in March 2011, the staff report summarized the rate factors. Where were we back then? Well, we're going to look at an accumulation of connection charges and put some in a reserve coupled with future payment from the developer that's anticipated to fund expansion of both water and wastewater capacity. So you got to kind of look at what you're spending now, what you need to accumulate for future capital improvements. And the council approved a revision of the connection charges in 2011 from $20,000 down to $12,350. Things are changing. The higher amount had assumed no payment from the developer, as I mentioned, that wasn't in the first rate study. And the lower amount assumed a significant payment in the future, as well as an additional $6 million grant received on the American Recovery Act from the federal government. So, what was going on here? Well, the main driver of the increase in the wastewater rate was the debt service on the new treatment plant. A new plant needed to be built to both meet new nutrient discharge regulations and to replace the existing plant that was nearing the end of its service life. The total cost of the wastewater plant project was about $19.2 million, but the town was fortunate. It got the Virginia Water Quality Control Improvement Fund and American Recovery and Reinvestment Act to cover almost 73%, $14 million of the cost of the plant. So that was really good for the town. And the remaining amount was financed by a 20-year no-interest loan provided by the Commonwealth of Virginia. And the debt service associated loan comprises most of the wastewater rate increase that went into effect. It wasn't the biggest increase as was anticipated. It was revised, went down, but it was still an increase. And then after the increases, there was a public commentary that the reason for the increase was because the developer at Bay Creek did not pay the town for their share of the cost of building the new plant as required by the annexation agreement. And that was kind of a misconception. That's not really what drove what was going on. What drove what was going on here was the world changed. The annexation agreement required the developer to pay the cost of expansion to accommodate additional treatment demands of the annexed property beyond the limits of the town's current permitted capacities. What was in the permits? The permitted capacity, going back to 1990, was 250,000 gallons per day. The town started planning to replace the old plant in 2006 to meet the new state nutrient removal requirements, replace the packaged plant, put in tertiary treatment, and the old plant was in poor condition and it was impractically upgraded, so you had to put in a new plant. So the town set out to design a plant for 500,000 gallons per day. The idea was to go get a permitted capacity of 500,000 gallons instead of 250,000 gallons. Still thinking back then that the economy is still roaring on in 2006, that even though you might not get the 3,000 units originally planned by Brown and Root, you might get a lot of construction out there in the Bay Creek area. And since the town was planning to build a plant with greater capacity than the current permitted capacity, the town entered into discussions with Baymark to pay their share under the annexation agreement. And there were a lot of discussions about that. Everybody, talking about, how do you interpret the agreement, how do you, lots of technical studies were performed, lots of rate studies were done, a lot of discussion up and back. But as that all progressed, the economy fell into a deep recession. And as the recession persisted, it became clear that the growth projections would need to be revisited after the economy recovered and the real estate market improved, and there was no longer a near-term need for an increase in the permitted capacity. So, the design process was halted in 2008, right when that recession is ongoing, and in 2009 the council decided to build a smaller plant of 250,000 gallons per day. So, the new plant has the same permitted capacity as the old plant, it's just more modern and can do nutrient treatment to meet current standards. So that minimized the risk of building expensive infrastructure that would be underutilized and avoided potential permitting dispute, because you've got to realize you can't just decide what plant to build. You have to be permitted to do it, and you have to show you have need to do it, and there would have been a huge battle to get the Commonwealth to permit a 500,000 gallon plant. So, a lot less money was spent to build a new plant, reduced the increase in the state waste load allocation, which ties to permitting, and a requirement for the developer to pay for expansion wasn't triggered because there was no increase in permitted capacity. So, The terms of the annexation agreement require the developer to pay at some point in the future, and if events transpire that a higher permitted capacity is required, and that's also true for potential future need to expand the capacity of the future plant. It's all potential. You know, a lot of things change. You get the economy going on, you got development going on, and you got technology changing. You know, one of the big focuses now is on reducing the amount of wastewater you had as opposed to treating more wastewater. You know, things like, you know, more efficient toilets, more efficient showers, and things like that. And golf courses manage differently. So who knows? Maybe in the future this will happen, but that's really where we stand today. So before I move to the second part of my presentation on eminent domain, council have any questions?
Yeah, I've got two. One just straightforward that really is relevant, but do you know if VDOT was involved with any of these earlier 1990, 1991 agreements that hoped them to do certain things?
Yeah, oh yes, they were all involved in that. And I mean, from what I see in the record, I wasn't at the time involved, but what I see in the record, VDOT was consulted with about what kind of studies had to be performed on traffic usage and, you know, what process they have to go through for
Okay.
and yeah.
All right, the second one has to do with the capacity of the plant. We've got a permitted capacity. And right now, we're not up to, obviously, that amount, but we should have some reserve amount for what I'll consider the town, and then a reserve amount for Bay Creek right now to get up to, let's say, the 250. Do we have a clear understanding as far as what will trigger the plant increase capacity and costs associated with it?
Well, first of all, you have a permitted capacity of 250,000 gallons.
Right.
Now, there may be a higher design capacity. Bob might be able to answer that. But do you know if there's a higher design capacity of that plant?
No, the permitted capacity is the design capacity. It's a little confusing because there is a different hydraulic capacity, which is triple that. So on a bad day, you can pump 3/4 gallons to the plant. But the design capacity is 250 on average. It has, when we built it, it has some features that would allow for easier expansion of 500,000, simply because you can't buy things small enough for 250.
And you might not have current numbers, but like what percentage of that 250 is being used?
We're looking at right now, but we're probably around 150,000 gallons per day on average.
Because I would imagine the town has certain expectations as it grows and fills out, right, with balance of houses and historic district, no less some of the industry perhaps that we may attract in the area. So we're going to be feeding a requirement for future growth from the town's perspective, no less the future growth for Bay Creek as they continue to build out.
Well, think about it. They keep part of the town. You can't separate them out. Okay?
Well, I have to separate the costs because of, go ahead.
And only under two circumstances would you do that. One is if they want to reserve capacity. If Bay Creek want to come say, you know, whatever happens in the town, I want to make sure I have at least this much excess capacity. They have to pay to get that reservation. Otherwise, it's a first come, first use basis.
Okay, first come, okay.
Okay, so now you've got round numbers, 100,000 gallons of unused capacity.
Right.
So, you know, however long it takes to get within the distance of needing to plan to expand it, it's hard to say. It's probably a long time in the future.
Well, and Paul, keep this in mind. Marina Village is part of the town.
Yeah, okay.
Because that's part of the town's growth, not Bay Creek.
Right. I'm just saying,
Yeah.
are we gonna get confused as we go into the future on this, you know, you can't expand the plant overnight. But as we project reaching that capacity based on whatever first come, first served is, we'll have to know what will trigger, how early do we trigger in order to get that additional
Well,
capacity?
that's why they keep track of the average flow rate for a month.
Yeah, I think Bob, you probably can speak to it as well as anybody, but there are definite triggers when you get to a certain capacity that you need to start planning and then you need to start building.
And you're going to hear that from the state too. because, reports are being submitted all the time. And in fact, the town was hearing a lot from the state about needing to improve its old plant. So when they start to see usage that is, getting up there close to capacity, they're going to be talking about what are you going to do differently? What is your plan?
My recollection is DEQ's guidance is 80%. You have to start planning.
And you may decide to do it in advance.
Right.
But again, it's as time goes on, it really becomes a little more complicated than it used to be 20 or 30 years ago, because you have all these interlinked issues. You have, if you have more demand, water is coming from someplace. Okay, so first of all, are we talking about the town's treated water? Are we talking about untreated water? Are we talking about what's going into the wastewater treatment plant? Are we talking about industrial or commercial waste that requires pre-treated would make a difference on how it has to be treated in the plant, what its impact on the plant is? And then, as I mentioned, what used to be hopefully the amount of water used by different facilities, whether it be a house or a restaurant or a condo, is less than it used to be because of technology improvements. And the town can influence that too by requiring certain things in the structures in the town. So, yeah, it's something you need to monitor. There's no question about it, you need to monitor. And at some point, we'll make a decision probably to hire a consultant to come in and look at the situation.
All right, so really the important takeaway for me is first come, first serve for the reserve right now.
Well, I don't call it reserve, the unused capacity.
Right.
Yeah.
You're right.
Yeah,
Right.
the unused capacity.
Okay.
Yeah.
Okay.
Yeah.
All right.
And so, the economy can do it. Well, it's not just the economy, it's what kind of development happens. Not all development uses a lot of water that goes through the treatment plant.
Right.
Some industrial uses, it may be that the agreement is that they have to treat their own wastewater. I mean, it doesn't necessarily have to be the town's facility.
That's what happened with Bay Creek. Bay Shore Concrete, sorry.
They should come. Now, I got you making
Yeah.
a mistake too.
That's what they pulled out.
Other questions related to the annexation, Mr. President? Again, it's a lot of history here, but it can be important for thinking about decisions. Mayor, can I take a question from the audience? Is that okay with you? Okay.
So it's fair to say there is no obligation from Bay Creek today, with all the amendments to the annexation agreement, that they have any responsibility on any of the expansion of the wastewater treatment plant.
I'm not going to, that's a question I'm not going to answer.
Okay, well, so, you know what?
Well, I'll tell you why. Because
We have a blogger
Yeah.
who puts out this negative stuff,
Right.
and it's not accurate.
Yeah.
So it turns people off, going,
Right.
wow, what's all this jibber jabber?
Yeah.
Well, let's put it in context.
Well, and that's why, if you go back through some slides here that address that issue,
Exactly.
I'd rather kind of stick with those. And the reason is, the town has a lot of varied agreements on a lot of different issues. And the town is always in negotiations with its constituents, whether it be a Bay Creek or whether it be other builders here. And, to get into what structure might be made, what deal might be made about what's done when, I just don't want to get into
But things have changed since the original annexation.
That's absolutely true.
So to reference the original annexation agreement is not germane to what is reality today.
I think comparing a 3,000 planned 3,000 unit development to what's there today is very different.
Thank you. That's,
Yeah.
okay, great.
When relative to the Martin property and the expansion of the connector road, you said that VDOT was aware of it. That's not true. I personally contacted VDOT about it, and according to them, I sent the annexation agreement to them. They said they had never seen it, never heard of it. And actually, the state's attorney general looked at it and said that he believed that the developer was responsible for paying for that road. I can send you the context. I can send you the email I got from them.
All I can comment on is that back in the 1990s, VDOT was involved because there's paperwork showing they were involved. None of the people who worked for VDOT were still at VDOT. So a lot of time, administrative entities and companies, they lose their corporate history, and I don't really have any knowledge about what happened recently that you're commenting on, and I really just can't.
Yeah, I just want to let you know that they were not aware of it.
Well-
The recent crew, the design people, were not aware of the annexation agreement. That's all I'm saying. So your statement that they were aware is not really accurate.
Well, I'm talking about the entity, VDOT, okay?
VDOT is mentioned in the annexation.
You know,
agreement.
VDOT
Yeah, I mean, they're
is
right
listed
in
the
there.
annexation agreement, it's a public document, and they had input to the whole process back in 1990. They may have forgotten all about it.
Well, they might have made a mistake, but if they were made aware of it at the time of the design, I think they would have probably looked at it and said, well, look, we don't have to pay for this.
Well, that's
That's up to their own.
yeah, that's up to, well, I would say this, don't assume that automatically anyone would have had to pay for that because of what VDOT did out there. That's a really complicated issue. I've not analyzed it, but it's not simply saying that there was a part of this annexation agreement and a road was improved and they had to pay for
And
it.
that's why we have the courts, and that's why it's considered a law. It's law number 27, and that's the reason why you need to go look at, you have to bring it up to the courts to find out, get an answer from the state, yes or no, on all this stuff. Just like looking at it and saying, well, I don't
And I'm
think
sure
they
the
need to.
Attorney General will make whatever the appropriate decision is about.
Like, how's he going to do that if the town doesn't bring it to him?
Why would we have to agree with
It's up to the Attorney General. It's up to the Attorney General and.
They say it's up to the town. The Attorney General says it's up to the town. I can provide you with the text that he sent me, because I asked him, I said, why didn't you know about it, and why are you not doing anything about it? He said, we can't do anything about it unless the town brings it to them as a case. And that's your job.
No, it's the town council's decision about whether it's to the benefit of the town to do that.
Right, and I agree with you, and if they decide it's not, it's not. I mean, that's what they're gonna have to do, but, I mean, that's,
Yeah, I have not been asked to analyze anything with respect to that issue as it sits today.
Gotcha.
All I know is back
That's
in
it, I'm good.
1990. Yeah, okay. I'm going to move on to the other part of the presentation so that we can, get you all out of here in good time. The other one's a little shorter. And Libby, is it up? Oh, jump ahead a minute.
She's magic.
You are. I appreciate that. All right. So, all right. This a little bit of a background on eminent domain, because like from various times, people have asked, that, whether in the government or whatever in the town have asked about using eminent domain to take property of the town. It's really active interest by council. We started this process before the new elections. I wasn't any one person. It's kind of a general interest to look at some properties with possible condemnation. So the issue is you've got to know about the process before you can decide whether to try to follow it or not. So basically, let me get paper copy now. The Constitution basically says you can't take property from a citizen without process of law and without just compensation. So that's mainly what's in the Fifth Amendment to the U.S. Constitution, and the 14th Amendment addresses due process. And the Virginia Constitution has a similar provision, but importantly, it places the burden on the condemner. So let's say the town wanted to condemn property to prove that the taking is for a public use with no presumption favoring the condemner. So you've got this burden to prove it's for a proper public use, and then also what you do, you have to pay fair compensation to whoever you took the property from. Damages. So when you take property, you have to pay damages, and it can be more than just physical damage to the property. It could be the negative effect on a right connected with the property, such as reduced development opportunities. And I cite a case here about Lincoln Dunes Condo Association of Virginia Beach, fairly recent, 2012, where the Supreme Court held that the locality's damage to the property owners repairing notarial rights it was compensable because the city's beach replenishment project was insufficiently related to the efforts to regulate and improve navigation. So the town improved the beach, didn't go through the condemnation process. An action was brought against the city, call this inverse condemnation, if you will, where they're saying the town didn't go through the right process, they owed money, and the Supreme Court said that's correct. So with respect to eminent domain power, it sits basically in Richmond, but they've delegated that power to various agencies, localities, and the Commission of Highways. You've probably all seen a little bit more about this when VDOT comes in and they do a quick take on property for the road. And there's other statutes that grant authority to special government entities such as a public authority, you know, a utility authority, water authority, what have you. And cities and towns may acquire property even outside of the boundaries without specific grant of authority when condemning for utilities and transportation purposes, special uses there. For any other public purpose, cities and towns must have a specific grant of authority to condemn outside their boundaries. So generally speaking, except if it's transportation or utility, condemnation is going to be inside the boundaries of the town. So this would be where, say the town decides they need a lot for some public purpose. And the grants of condemnation authority to localities are contained in 15.2 of the code, and then the procedure requirements are in 25.1. They could have made this more complicated if they tried. So if you want to look at what the substantive issues are, it's in 15.2. If you want to look at the procedural steps, it's in 25.1. You know, rather than separate references to condemnation restrictions based on the status of a county, city, or town, Title 15.2 was amended to generally use the term locality, which includes counties, cities, and towns as the context may require. We tried to simplify it a little bit. We weren't terribly successful. And then statutes delegating eminent domain power strictly construed against the condemnor. So you've got to really be tight. You've got to be right in these statutes. You've got to cross your T's and dot your I's when you go through a condemnation process. It's not going to take it lightly. The towns generally have the same authority to exercise eminent domain as cities, and cities generally have the same condemnation authority as counties. So in order to figure out what your authority is, you kind of get out of go uphill to the county and see what their authority is. And under Title 15.2, the powers to condemn include the following public uses, and I list them all out there. You know, examples would be roads and bridges, educational purposes such as schools and related facilities, courthouse and parking areas, housing boards, things like that. So it's a whole list of listed public uses. And under Title 15.2 of the code, all localities must use the procedures in 25.1, and then the only exception is in 33.2, that's the VDOT dictate procedure, which I'm not going to guarantee for right now. So basically, you have to hold a public hearing, and then the town may acquire land within their boundaries, or within 3 miles of their boundaries for business or industrial development, but not by condemnation. So you got. I'm talking. This is acquisition now, rather than condemnation. So if you want to go buy land, you can buy it in your boundaries or within 3 miles of your boundaries for business and industrial development, but you can't use condemnation for that. As I mentioned a minute ago, when you go outside the town, you can only do it for transportation or utilities. So after conducting a public hearing, any property so required may then be sold to a business. So the town can go out and buy a piece of property, and they decide they don't want it, they can turn around and sell it to a business. Just have to have public hearings. And I go through this because it interrelates with the condemnation process a little bit, because there are differences in circumstances where you can acquire land versus trying to condemn property. Basically, the power of condemn extends to all interests in the property, so you can get the whole thing, all the rights that went with it. Water rights, mineral rights, whatever it is, air rights. You can't condemn property of the Commonwealth. There's some exceptions, but I won't go into that. Just assume you can't do that for right now. And you can't condemn property of other localities or political subdivisions by each other. And the condemnor must obtain the approval of the State Corporation Commission to take property for any, from any other corporation. So if you have a corporation that has eminent domain powers and you want to take their property, you've got to get permission from the State Corporation Commission. You're not likely to run into that one. I'm sure you're good. It is an issue. Okay, so I mentioned listing some public purposes in a few slides back, but there's another overlay here, which is property acquired for the public use, for a public purpose, has to also be for a public use. We'll change the terminology. The definition of public use is controlled by another set of the Virginia Code, 1-219.1, and I've listed here several of these to bring them to your attention, which include public facilities. And I'm going to go to the next slide and give you examples of public facilities. So these include library facilities, law enforcement, office facilities, and things like that. So you got to have first a public purpose, and then you have to have a public use, and they're a little bit different. So you have to go through that when you're doing an analysis. You can't really do that until you have a specific opportunity that you're looking at. And then I will mention that there are some inconsistencies between public uses in section 15.2 and public facilities listed in 1-219. And as an example, 15.2 does not list the following public uses, even though they're listed as public facilities, including library facilities. Now, I gotta believe that this was a mistake, okay, and that it was never intended. And there is a provision in 1-219 that says, and I quote at the bottom here, the provisions of this section shall control to the extent there are any inconsistencies between this section and any other general or special law. Otherwise, nothing herein shall be construed as abrogating the power of eminent domain delegated independently of this section. But there are no cases on this. So if you were in a situation where you were going to, say, condemn for a library facility, you might want to get an opinion from the Attorney General as a step in deciding whether to go forward. I don't think it's likely to be a problem, but it's hard to say, especially if you have a resistant property owner. There are a lot of limitations to eminent domain. Some people think, oh, we're the government, we just take property, we just decide to do that. Well, that's not quite true. First, no more private property may be taken than that which is necessary to achieve the public use. If you only need an acre, you can only take an acre. You can't take an extra half an acre. But you can plan for some contingencies. So that's one issue. And the public interest has to dominate in the purpose for taking it. There's a judicial determination of public purpose. And there was a 2012 amendment to the Virginia Constitution that provides the condemner bears the burden of proving that the use is public without a presumption. So before that, it was on the challenger, the property owner, to argue that it wasn't a proper public purpose. And there was a lot of fighting going on, especially around some universities, where the universities were taking land that had dorms. Discussion about whether that's a proper public purpose. The presumption was it would be proper. Now it's flipped on its head. The presumption is it's not proper. You have to prove that as the public entity. And as I mentioned, you can get some property to meet future needs, but you need to show that it's a necessity. I will tell you, most of the time, the courts will defer to a good finding, going through the right steps by the public body, that it is a public purpose and it is a necessity. But I'll point out one decision here, which is not too old, 1987. The court held that the city, in attempting to acquire a parcel for a visitor center, did not define the proposed facility sufficiently to establish a necessity for the taking. So you get your home, you're going to build a visitor center, really go through, this is what we need, and this is why we need it on that location. Maybe it's where everybody drives through, everybody walks through, and we own a piece of property over here as the town, but it's not a good place for it. We really need to have it over here. You build a good record, it's probably going to be approved by the courts. So once you get to the point where you decide that, okay, I've got a public purpose, I've got a public use, I've got a necessity for this, then you've got to go through some procedural steps, and these are conditions precedent to going forward with the condemnation. You got to do a title search. You need to file a certificate of take, and you have to file a certificate of deposit to acquire a fee simple interest. And then you must determine the nature and extent of all the ownership interests in the property, including anybody who has easements or whatever, anybody who has any rights in that. And then you take that report and you have to give it to the owner of the property. And you have to make a bona fide effort to buy the property from the owner. You can't just jump into condemnation. You have to first give this report and then go through the process of determining what a fair value is and make a bona fide effort to buy the property. And it's only when you reach impasse and you can't buy the property from the owner for what you think is a fair amount that you can then jump to condemnation. The other issue that comes up is if this property is occupied by individuals or businesses, you have to provide assistance to relocate the family and relocate the business and pay business relocation and family relocation expenses. So, you know, you don't get a voluntary, sale. You have to think about the fact that the condemnation process is going to have other costs associated with it, that might affect your decision about what price is and go back to kind of rethink about the private sale. And you have to give proper notices to people. You can't to find a new place to live and move their business. There are real property acquisition guidelines in the Virginia Code, and they need to be followed to the greatest extent practicable. In acquisitions, even if they don't involve relocation, because 25.1-417 was written with a lot of details about what to do when property is occupied by a business and a person, to have a really detailed procedure on what you have to do. But they say even if it's vacant property, you should follow that procedure to the extent practical. So you want to give the landowner an opportunity to accompany your appraiser, and the condemner must offer the full amount of just condemner. The town would have to offer the full amount of just compensation to the landowner, which must be at least its appraised value. And then the landowner must be given a written explanation of the basis of the offer and a copy of any appraisal if the acquisition is in excess of $25,000. And you have to acquire the entire property that you're going to, that you had appraised for condemnation. And then finally, if you're going forward, you have to have an ordinance or resolution. And we talked last time about how there's a quirk in the code about not clearly distinguishing between what is an ordinance or resolution. In this particular provision, they say ordinance or resolution, authorizing use of eminent domain. I think, frankly, the reason that's in there is because the power of eminent domain resides in what I'll call some authorities. They're like corporate entities, and they don't have ordinances. So they would pass resolutions. I think for the town, you use an ordinance. And then you file a petition, which is the judicial part of the judicial proceeding. So there's parts of this that the town can handle itself, or consulted. But there's a point at which you have to have legal counsel involved, but you can't file anything in court without a lawyer. So you have to file a petition that shows that all these prerequisites were followed. You have to have a proper description of the property. You can include more than one parcel in the petition. And then you have to go through a lot of special notice requirements for all the landowners. And then the landowner selects a jury. Jury commissioners established pursuant to the code. And then finally, if the award exceeds 25% of the initial written offer the town made, okay, then the court may order, and usually does, the condemnor, the town, to pay the owner reasonable costs, except for attorney's fees, and reasonable fees and travel costs, including reasonable appraisal and engineering fees incurred by the owner, up to 3 experts, or as many experts as called by the condemnor, who testified at trial, whichever is greater. So, end of story is, before you condemn property, you really need to go through the analysis to figure out that it's really important. And there's some property that is absolutely unique, There's waterfront property, that may not be replaceable. Maybe the only place you can put something. It may be that, for various reasons for safety purposes, you might feel that you've got to have a fire station in a particular spot, or a police department in a particular spot, where the only way to service utilities is to have utility service or a pump station or what have you in a particular spot. And it may drive you to condemn if the owner won't sell. The other circumstance in which you see condemnations is where you can't find the owner. You might be able to identify who that is through the property records, but you can't find them. So the only way to do this is to go through a condemnation process. And that actually happens. That's probably the more frequent use of condemnations throughout the Commonwealth, as opposed to condemning for some planned purpose. So that's an overview of that. Any questions from council? Okay. Well, thank you. Happy to
Thank you.
update you. I think I finally caught up on the 4 presentations we kept planning to do, but getting rolled forward because of various events, and